Hi, this is Rebecca Carter from Full Sail University with this week's segment of Internet and the Law. This segment of our show will be dedicated to Priceline Generalissimo El Guapo, aka William Shatner, aka Captain Kirk. In this segment, we will review and discuss website terms of agreement and conditions for Priceline.com and determine the following. 1. Is the agreement a valid contract? 2. Does the visitor assent through clicking the I agree button, or should the user be bound solely through use of website, in particular if the user has not read the agreement? 3. What are some of the user's obligations under the terms of contract? 4. Does Priceline have any obligations under the agreement? 5. Are any of the statements in the agreement that are unenforceable? If so, why would the company put those provisions in the agreement? And finally, what changes would you recommend to the agreement? Priceline.com is a travel services company that may help visitors obtain discount rates for travel-related services such as hotel bookings, car rentals, and airline tickets. The company relies on participation from third-party vendors and websites to offer discounted rates and services to Priceline website users. Let's first examine if Priceline agreement and conditions are a valid contract. In order to have a valid contract, there must be three essential elements in place. These elements are an offer, number two is acceptance, and number three is consideration. When visiting Priceline.com, the visitor is not obviously made aware of any sort of contract to accept the terms of use by any means of physical signature, e-signing, or an I accept button. The visitor will view many offers for special deals and discounts and can book a hotel, but there is no reference to accepting a contract with Priceline during that process. There's also not a significant attempt to make a visitor aware of any contract. There's just a small, inconspicuous link in the footer of the page. With that in mind and legal elements necessary to make a contract binding, in my opinion, the contract terms and conditions are not binding contract. Does the visitor assent through clicking the I agree button, or should the user be bound solely through the website? Upon clicking the I agree button, it could be argued the visitor was aware of the contract. The Priceline.com contract validity may be confirmed if the visitor acknowledges the contract via electronic signature or I agree under the law in regards to 15 U.S. Code 7001 General Rule of Validity. A. In general, notwithstanding any statute, regulation, or other rule of law other than the subchapter and subchapter 2, with respect to any transaction in or affecting interstate or foreign commerce, number 1, a signature contract or other record relating to such transaction may not be denied legal effect, validity, or enforceability solely because it's in electronic form. And 2, a contract relating to such transaction may not be denied legal effect, validity, or enforceability solely because an electronic signature or electronic record was used in its formation. However, the visitor should not be bound by solely using the website. If an attorney was well versed in UX website design, the attorney could argue that the contract was in the least conspicuous place for any notice to be aware to the visitor on the website. Thus, they could not agree to something they were not aware of, or could they have considered the small footnote of a contract. In the case of Zappos 2012 data breach case, the courts did not uphold Zappos' browser wrap argument when the link to terms of agreement were not obvious. Later, the court reinforces how unimpressed it was with Zappos' browser wrap argument by citing the arbitration provision found in the Zappos.com terms of use purportedly binds all users of the website by virtue of their browsing. However, the advent of the internet has not changed the basic requirements of a contract, and there's no agreement where there's no acceptance, no meeting of the minds, and no manifestation of assent. A party cannot assent to terms of which it has no knowledge of constructive notice, and a highly inconspicuous hyperlink buried among a sea of links does not provide such notice. Because plaintiffs did not assent to the terms, no contract exists, and they cannot be compelled to arbitrate. What are some of the user's obligations under the terms of agreement, and does Priceline have obligations under the agreement? Priceline.com Terms and Conditions outlines a large list of user responsibilities while visiting the website, while it proceeds to limit the liability of Priceline.com and every third-party vendor which Priceline.com represents. It also states in the terms and conditions to discontinue use of the site if you disagree with these terms. Are there any statements in the agreement that are unenforceable? If so, why would a company put those provisions in the agreement? One could argue that all the agreements are unenforceable if Priceline is looking for protection under the browser wrap agreement. Companies will try to mitigate any and all liability exposure in fine print. In most cases, there is a presumption that they will win an argument due to better knowledge of the legal infrastructure and better legal representation. What changes would I recommend to the agreement? I would make some sort of I accept terms of conditions be clicked before viewing the special offers. I would keep the terms and conditions in the footer of the site. Let the visitors put in their information and details of what they would like to see. I would also have a very inviting teaser for the visitor, but have them electronically accept the terms and conditions before viewing the offers. This would comply with all the terms of a contract under the offer, acceptance, and consideration. I'd like to thank you for listening to my presentation today, and if you have any questions, please feel free to contact me. Thank you.